All right, so I have joining me Judge Birmingham from Texas. I appreciate you're a frequent legal analyst here with us on Law and Crime. Thank you for joining us again today.
Yes, ma'am. It's always good to see you. Always good to be here.
Well, I'm very happy to have you because I have to tell you, as a judge pro tem in Georgia, here's what's driving me crazy about this trial, and that is the number of objections, and one step further, the number of objections that are being sustained. And so we have, it's almost, I have a cheat sheet when I became a trial attorney 20 plus years ago that I would use for a list of objections. And Judge Birmingham, I almost feel like I have it in front of me, and every type of objection is warranted. We have speculation beyond the scope, assumes facts, not evidence, and a lot of those are sustained. How does that affect the judge, first of all, and or the jury, in your opinion?
Well, it is a test of patience for the judge. You sustain a couple, then you have to start thinking ahead. Is the repeated question going to have an impact and cause a mistrial? Probably in a situation like that at the next break, I might take him aside and take him back maybe in chambers and say, look, we got to figure this out because this ain't working. On the other, and additionally, from the lawyer standpoint, you don't want to make the jury either upset if you're the one who is asking all these repeated questions. Sometimes if you keep getting an objection sustained, you might want to just abandon ship for a little while, don't release the witness, get together with your trial partner, figure out how you can get it in. And on the other hand, the other side is looking at this, maybe they're showing through their objections that this prosecutor or the defense lawyer is unprepared, they don't know what they're doing, and they're going to try to use that as momentum to help convince the jurors to vote their way.
And it's going to be interesting because I also see that this could technically be used as grounds for appeal. I mean, the number of, I just want to sit down and say, listen, there's a correct way to ask a question, and if you ask it correctly, you don't necessarily draw an objection. So I know I'm frustrated watching it in that respect. I appreciate you staying with us. We're going to take a short break, but please come back. We're going to return to the McStay murder trial with Judge Birmingham. All right, so again, we were replaying testimony, and that was cross-examination of Michael McStay, who was Joseph McStay's brother. Part of the reason this testimony is so important is because he was the first person to go into the McStay's family home in 2010 when they were concerned about, where is this family, where's my brother, his wife, the kids, I haven't heard from my brother. And so there was a little bit of confusion about what he recalls and what he doesn't recall. For instance, the 9th or the 10th is the day that he talked to Merritt. And when he went on the 15th, he can't necessarily recall what time of day it was that he went to the house, whether or not the detective was outside when he got there. Judge Birmingham, I'd like to bring you first back in to say this. It was 2010, 8 years ago. Would it surprise you that a witness may not be able to recall some of those small details 8 years later?
Oh, absolutely not. That's a very common thing for a case that's even 3 months old. It's the human mind doesn't work necessarily in details like that. So that's why you want to fall back on the things that you do know, whether it's a witness statement, maybe the witness took notes, maybe the witness talked with a detective or an investigator, and the investigator took notes. Those notes become vitally important, especially when you move into the realm of a cold case like this one, where we're talking about incidents that happened nearly a decade ago.
Right, and I think the other piece that's important to remember is in 2010 when this happened, initially there was testimony that it didn't appear as if anything had happened in the house, that it wasn't a crime scene, and then there was some follow-up to that about maybe the family went to Mexico voluntarily. So it's not as if they immediately discovered a crime had been committed when he first went into the home. Please stay with us, Judge Birmingham. We're going to take a short break. Viewers, McStay is expected to resume, and we'll join it when it does. Please come back after this break. All right, Bruce Carter is testifying now about, and let me clarify, this is called the Pink Dog, and it's on the border of Mexico. Judge Birmingham, let me bring you back in. I know you're going to be signing off at 2:15, but I want to take advantage of time with you and ask you this. So he's testifying as to the policies, procedures, process around having cars towed. I'm assuming this is going to lead into testimony that the McStay family car may have been found there and been towed. What do you think? Is that the direction you think this is headed?
Yeah, they've kind of, as I understand from the opening statements, I believe it was the DNA of the defendant was found on the steering wheel and also the car the gear shift. And in order for that DNA, if it is proved to be the defendant's, to have really any meaning, they've got to, the prosecutors have to try to nail down when the car was there to the best of their ability. Obviously, nobody's taking a record of when cars are parked here and there, so they've got to try to establish by common practice where the car was found to try to give meaning to the DNA evidence. I bet we're going to hear about towards the end of this case.
All right, so it's going to be interesting to see where the prosecution goes from here because there are a lot of pieces. This trial is expected to last 6 to 8 months, a crazy long trial. So, Judge Birmingham, I know you're needing to go do some other things. Thank you, as always, for joining us today on Law and Crime.
Just 6 to 8 months is a long time.
All right, we're going to take a break. Come right back after this.